Ji. Assalamu alaikum ji. Everyone, my name is Aizaz Ahsan. As Mubashir Saab said, I am an advocate of the High Court. My main area of practice is commercial litigation with a focus on tax and constitutional disputes. This is a small workshop that we're conducting. The broad structure of it is that I will be sharing a few canons of interpretation with all of you, and I would hope that you guys will interact with those canons of interpretation in terms of the discussion that we have. और फिर हम वहाँ से आगे सवाल ले सकते हैं. तो जी, just to briefly explain what the topic is, interpretation of legal texts in parts to it. The first part is what are legal texts, and the second part is how do we interpret them. So as far as legal texts are concerned, we're going to limit ourselves to the following, which are the Constitution of Pakistan, statute, ordinances promulgated under the Constitution. Then there's delegated legislation, which are rules and regulations, usually made. Rules are also there. And then we have statutory regulatory orders, which are executive notifications issued under statutes and ordinances. The idea is that we limit ourselves to only these legal texts, even though we have other texts which might be included within this framework, such as judgments or even academic articles or other scholarly works. लेकिन हमने अपने आप को सिर्फ इसके लिए लिमिट किया है क्योंकि we want to interpret what's written within them and not other items. So just moving on briefly, the idea is that principles of interpretations have come from the judiciary. You have a classic understanding of the constitutional separation of powers working in Pakistan. We have the parliament, which enacts laws. We have the judiciary, which interprets those laws. And the interpretation of those laws is done on a case-to-case basis, where they have certain facts before them, and then they try to understand what is the scope of that law which has been passed by the parliament. And over time, we have these principles evolving through these various applications which are before the court to understand how a certain phrase may mean something or the other. यहाँ पे there's an important distinction to make. Some of these principles may carry over to all types of the legal texts that I've defined. Others may only apply to a certain subset of texts, they may cross multiple categories. So it entirely depends on the canon of interpretation that we're looking at or the principle that we're looking at, and then see whether or not even it applies to the text that we're looking. But sometimes, like I said, they just apply across the board. One of them that I've written is the rule against redundancy. Author of a text, of a legal text, it should be given its due effect, because otherwise you would be defeating the intention of the author. So that rule applies across all types of legal texts, which are, of course, even the Constitution or the statutes or ordinances or even SROs. So it applies across the board. I may also add that even though most of these principles have come through judicial analysis, some of them have now been also codified into law. One example is of Section 107 of the Income Tax Ordinance, where the Income Tax Ordinance itself tells us how to apply double taxation treaties and how to interpret them in terms of the local law and the international law. So you have this nice mesh of principles now forming. Some of them are also in contracts, where you have the contract signing how to interpret a certain clause, maybe like in case of a severance clause and so on. But most of these principles, again, have a judicial evolution behind them. And that's what we'll be probably focusing on most of the time today. So the first principle that I would just like to highlight is the presumption of constitutionality. This is a pretty basic principle, which I think applies across the board to every statute there is. And the understanding that we have of this principle has been recently again restated in the case of LD versus Ibrana Tivana, which of course states, as the slide shows, there is a presumption in favor of constitutionality, and a law must not be declared unconstitutional unless the statute is placed next to the Constitution, and no way can be found in reconciling the two. So this is the declaratory part, where the presumption has been stated. It should not be declared unconstitutional unless it can't be reconciled. The interpretive principle, which is backed with this presumption, is the second part of this paragraph, which says, where more than one interpretation is possible, one which would make the law valid and the other void, the court must prefer the interpretation which favors validity. Now, this presumption caters to the basic understanding again of the separation of powers and how the judiciary has a democratic deficit when it comes to reviewing legislation. They, of course, are unelected, and the parliament is entirely elected. And for the unelected judges to tell us how to interpret a text or how to review a text should be done with circumspect and should not be just done in a manner which would make everything unconstitutional. So this type of challenge applies, this type of, presumption applies across both types of challenges. So we have two common types of challenges to a statute. One of them is that it is a violation or it is in violation of fundamental rights. And the second type is of an issue of legislative competence. In respect of fundamental rights, it's pretty obvious what it means. If you have a statute which is passed by the legislature, we may challenge it by stating this particular act is unconstitutional as it violates one of the fundamental rights enshrined in the Constitution. An example of this is the judgment in respect of immigration law. Lahore High Court has recently declared it as ultra vires the Constitution because it violates Articles 19 and 19A of the Constitution. It's in violation. It's been rejected. It's been said it's ultra vires. It can't hold the field any longer. The issue of legislative competence is slightly different. We have legislatures which make the laws. We have the federal legislature, and then we have the provincial legislatures. An issue of competence arises where a legislature seeks to a law which the legislature should have the power to do so. So, for example, you have the Federal Excise Act, which is a federal act made by the federal parliament, obviously, which seeks to impose sales tax on service, which is now a subject with the provinces. So the provinces have their own dispute with the federation, stating that the federation has no way of making this law and they should not be allowed to make this law since it's the provincial domain. So those are the two types of challenges. This presumption applies across the board to both types of challenges. So you would try to read every statute which has been passed validly by the parliament as being in line with the Constitution, unless, of course, there is just no way of reconciling the two. So you must favor the interpretation which favors constitutionality and not unconstitutionality. So an example of this presumption working in real life is the case of SSGC versus Pakistan. This is reported as 2018 SCMR 802. The validity of the Industrial Relations Act 2012 was challenged. So this was a law introduced by the Federation, which sought to protect the rights of persons working in transprovincial establishments. So if you are a worker working with a large multinational in Pakistan, and you have offices that multinational has offices across each province, then you would want to be protected under a federal act so that you may create a trade union which may across the provincial boundaries. So if I'm any kind of working and I have a worker, if I have workers also in Punjab, I would want a federal trade union, which would then cover my rights and would be my collective bargaining agent. And if I have any disputes with that company, then to be protected by the National Dispute Resolution Center, which would be the National Industrial Relations Commission. So this was introduced by the Federation. A dispute then arose in terms of the competence of the Federation to introduce this legislation because of the subjects on the concurrent legislative list. Now, the concurrent list was abolished through the 18th Amendment, and it referred both the Federation and the provinces to legislate on any matter which was enumerated therein. There were two specific entries in that list, which were labor practices and trade unions, entries 26 and 27. And the argument raised before the Supreme Court was that the NIRC law, that is the I-12 Industrial Relations Act 2012, will be covered by these two entries, the labor practices and unions. And since this list had been written, the provinces now had capacity exclusively to make any law in respect of labor practices and trade unions. The Federation, it was argued, had no capacity or no competence to make any such law, even though they had done so through the Industrial Relations Act 2012. The Supreme Court uses this principle. It says, in this regard, it should be noted that there is always a presumption in favor of the constitutionality of a legislative enactment, unless ex facie it appears violative of any of the constitutional provisions. And in a case where two opinions with regard to the constitutionality of an enactment are possible, the one in favor of the validity of the enactment is to be adopted. So this is just a reiteration of the same principle. The Supreme Court then went further, stated it is also a cardinal principle of interpretation that law should be interpreted in such a manner that it be lived rather than destroyed. The courts should lean in favor of the constitutionality of a legislation, and it is thus incumbent upon the courts to be extremely reluctant to strike down laws as unconstitutional. So this presumption carries a heavy weight. It is clearly very burdensome and can't be just easily discharged. Faced with the fact that the concurrent list had been omitted and the subject of, again, trade practices, labor practices and trade unions had been omitted, the Supreme Court nonetheless interpreted three other entries of the federal list widely to uphold the varies of the Industrial Relations Act. And those were external affairs, the implementing of treaties and agreements. Number two, entry 32, international treaties, conventions and agreements, and international arbitration. And number three, entry 13, interprovincial matters and coordination. The reason for doing so in respect of entries 3 and 32 was that Pakistan, as the federal government, had entered into various conventions given by the International Labour Organization. And those were clearly in respect of international conventions or dealt with the external affairs of the Federation. Therefore, the Federation had the link to pass any such law which had a connection with the external affairs or international treaties. And by reading these entries widely, the presumption of constitutionality also being read with it, the IRA was held to be was intra vires the constitution. The competence issue was in favor of the Federation. Now, there are a few issues with this judgment, as has been highlighted by a number of commentators. The first issue, of course, is that this kind of waters down our understanding of federalism. Federalism, of course, is that you have three tiers of government. You have the federation, you have the provincial government, and then you have the local government systems. And by giving certain subjects back to the federation, you are weakening the democratic function of your state, that the subjects should be devolved as far as possible so that the person who is closest to them should be able to legislate on them or at least work on them. So this is again, the comment on this judgment is that even though every statute is presumed to be constitutional and you may read certain entries widely to include its constitutionality, the problem remains that you may have other effects from those judgments, such as the weakening of federalism in this part. So one way of applying and preserving the constitutionality of a statute is by reading legislative entries widely. Another is by simply reading down the offensive part of the legislation. And that's the principle of reading down. So this was discussed in a recent judgment of the Sindh High Court. This is Pakistan Sugar Mills Association versus Pakistan, PL 23 Sindh 66. The facts were pretty simple. An order was passed by a four-member bench of the Competition Commission of Pakistan in respect of PSMA. Two members of the Competition Commission passed the order in favor of PSMA, and two persons passed the order against the PSMA. So there was a split decision. Two was the split. Two persons passed order in favor, two against. The chairperson then sought to, since there was an equality of votes, sought to break the deadlock and did so by casting a second vote in favor of her own opinion under Section 24 sub 5 of the Competition Act. There was dispute in terms of what the and whether such provision was ultra vires the Constitution. Now, Section 24 reads meetings of the Commission. Subject to this section, the chairman may convene such meetings of the Commission at such times and places as he considers necessary for the efficient performance of the functions of the Commission. So this, of course, is in respect of meetings of the Commission being the operative word. 24 sub 5 then states, in the event of an equality of votes, the chairman shall have a casting vote. An argument was, of course, raised before this in the High Court that either Section 24 sub 5 is completely ultra vires the Constitution because it is granting the chairperson two votes in respect of all proceedings, or it should be limited to simply only administrative proceedings so that its ambit is reduced and any violation of fundamental rights is completely taken out of the question. So the Sindh High Court stated at page 90B of the decision that with this understanding of law, I have reached to a conclusion that there should not have been a situation of even number of member of commissions in a quasi-judicial proceeding. However, in the current situation, the event of an equality of votes reached and hence the chairman, chairperson, and or any other member already rendered opinion cannot be saddled with the additional responsibility to cast a vote to untie the knot, as it would destroy the balance of each independent judicial mind being applied to a triable question and adjudication. This provision of Section 24 sub 5 of the Competition Act thus be read down to the administrative functions and operations of the Commission. Now, the understanding is that if the CCP is acting in any quasi-judicial proceedings, such as issuing any show cause notices or passing any orders which are imposing fines or so on, which are the enforcement of the law of the Competition Act, then for those proceedings, Section 24 sub 5 cannot be used. But for any administrative functions of the Commission, such as, again, the language is meetings of the Commission. A meeting could be for any reason. It could be for hiring a person. It could be for the increments allowed to a person or a bonus to any of its employees. For any such administrative meetings, the Commission the chairperson shall have the authority to cast a second vote. But for any quasi-judicial proceedings where there is a subject matter of rights of a person involved, the Competition Act or Section 24 sub 5 of it should not be allowed to be read in a manner which allows the chairperson to cast two individual votes, as that would completely break the entire structure of the rule of law. And that's what's been said by the Pakistan Sugar Mills judgment by the Sindh High Court. So we have two examples now of how the presumption works. There's, of course, reading legislative entries widely. The second example is of reading down certain offensive parts of a legislation to make sure that they're in compliance with the Constitution. A new thing that's been added to our jurisprudence is reading into the Constitution. That's the judgment of Aam Log Ittihad versus Election Commission, PLD 22, Supreme Court 39. Now, the facts are slightly interesting, and the various provisions of the Constitution have to be understood with great clarity because there are a number of them and they may end up confusing everything. So the first fact is that the Election Commission received certain new amendments through the 22nd Amendment to the Constitution. Retired judges could now become also members of the Election Commission. As per Article 195, a judge of the High Court retires at the age of 62. Article 218 sub B allows retired High Court judges to become members of the Election Commission, but it also fixes the age of retirement at 65. So the question was, when could a High Court judge become a member of the Commission? Again, a High Court judge retires at the age of 62. Under Article 218 sub B, you can become a member of the Commission, but you're supposed to retire at the age of 65. Now, Article 207 sub 2 of the Constitution was in dispute over the interpretation was required of this. And that states a person who has held office as a judge of the Supreme or of a High Court shall not hold any office of profit in the service of Pakistan, not being a judicial or quasi-judicial office, or the office of the Chief Election Commissioner, before the expiration of 2 years after he has ceased to hold that office. And now, firstly, आप भी देख सकते हैं कि this is a fairly wordy provision, and it's not been drafted with great clarity. I think there is a double negative involved, which shouldn't have been there. But even otherwise, the issue becomes that a judge of the High Court retires at the age of 62. As per this provision, you have an expiration period of 2 years, which is, of course, that becomes the High Court judge will retire at 62, will serve an expiration period of 2 years, and then would have the capacity to become hold any office, which is, again, not being a judicial or quasi-judicial office. The Supreme Court in Aam Log Ittihad was then tasked understanding how to read Article 2072 with Article 218(2)(b). The Supreme Court said that since you were retiring under Article 218(2)(b) at the age of 65, and since under Article 2072, you could only be a High Court, you could only join as a member of the Commission at the age of 64, Article 2072 required certain a renewed interpretation of the law, at least. Since, again, if I were to read it again, it says, a person who has held office as a judge of the Supreme Court or of a High Court shall not hold any office of profit in the service of Pakistan, not being a judicial or a quasi-judicial office, or the Chief Election Commissioner. So we have to also emphasize on the fact that 2072 notes that you can become the Chief Election Commissioner within a period of 2 years, and that bar does not apply. But you can't become a member of the Election Commission. Of course, those are two different offices. So the Supreme Court wanted to make Article 2072 and 218 to be read as harmoniously as possible, so that more and more High Court judges could be eligible for the office of being a member of the Election Commission. So the Supreme Court then tries the doctrine of reading in for the first time in Pakistan. It says, having carefully considered the matter, we are of the view that the present case is an example of the clearest of cases where the intent behind the constitutional amendments is so obvious and so patently requires appropriate action so as not to defeat the manifest objective thereof, that the constitutional rule of reading in can and ought to be invoked in the narrow and limited sense identified in para 28 above. Accordingly, we hold that from the 22nd Amendment onwards, the words or member of the Election Commission are to be read into Clause 2 of Article 207 after the term Chief Election Commissioner. Now, what the provision now reads as, after certain judicial intervention, is that you have the words or member of the Election Commission being almost legislated into the Constitution at this stage. So it now reads, a person who has held office as a judge of the Supreme Court or of a High Court shall not hold any office of profit in the service of Pakistan, not being a judicial or quasi-judicial office, or the office of Chief Election Commissioner, or member of the Election Commission before the expiration of 2 years. So through this novel interpretation of Article 207 sub 2, a judge of the High Court can now become a member of the Election Commission, even though the 2-year period has not expired. Which is, of course, a completely new thing in our jurisprudence, even though it does have some backing in Canadian jurisprudence and even other jurisdictions around the world. But this is completely new to us. Analysis of this is judgment is pretty obvious. Should judges, of course, with their democratic deficit, be allowed to legislate in this manner and also legislate in terms of the Constitution, not just a statute or even an ordinance? We have certain judgments from the Indian jurisdiction and even our own, where there's some really creative interpretation of certain phrases to include certain words within those phrases. But to actually go on and state that certain words must be read into the provision is certainly a new thing, and I don't think it's been done before in Pakistan. And we have, of course, other jurisdictions tackling this in a very different manner, where they simply state to the relevant legislature that maybe an amendment needs to be carried out to give effect to whatever else you've legislated, and not just do it yourself. So this is, of course, an interesting way of now resolving certain disputes, but the parameters of this doctrine have not been clearly demarcated as of yet, at least. So
we have a question in the Q&A box. So Sela Rahman, she's asked, what's the difference between holding office and becoming a member?
So if this is in respect of so this is a person who has held office as a judge of the Supreme Court or of a High Court. This is the office, of course, as being a judge of the Supreme Court or the High Court. And again, if the question is in front of me again, a member of the Election Commission is completely different from having held as an office of being a judge. So that's the difference between the two.
All right, thank you. I hope that answers your question. Please proceed.
Gigi. So moving on to, again, a few other examples of interpretive principles. We have the first principle that's written there, that's nociter e socius, or whatever else you want to call it. I'm not sure what the pronunciation is. What it means is that a word is to be read with its company or in the context of the provision. The first example of this principle is Wazir Ali Industries that I've written. There, the issue was in terms of Section 156 of the Constitution, of the Income Tax Ordinance. 156 says, every person paying prize on a prize bond or winnings from a raffle, lottery, prize on winning a quiz, prize offered by companies for promotion of sale, or crossword puzzle shall deduct tax and such rate. Now, again, just to read it again, the word prize features in a number of situations within Section 156, that being a prize bond, winnings from a raffle, lottery, prize on winning a quiz, and by prize offered by companies for promotion of sale. The issue was whether free goods given to distributors fell under the meaning of a prize. The Sindh High Court stated in its decision that the term prize should be used, the term prize used in the instant phrase has to be interpreted in such a manner which may correlate with the remaining words of the entire phrase, so may it reflect the true intention of the legislature. The reasoning which is then attached with this principle is very thin. It doesn't really explain how using the context of the phrase, using the term prize within the phrase under Section 156 means that free goods given to distributors should be a prize, but it simply states that the context so determines it. This is one of those decisions where I think the principle wasn't perhaps accurately applied, because my understanding of a prize is that it's usually for a contest. So if I'm competing with someone, and as stated within Section 156, that kind of becomes apparent that if you win a prize for a prize bond, or a raffle, or a lottery, or a prize on a quiz, or even for a crossword puzzle, you are then allowed to deduct certain part of the payment made to me as tax. So, for example, if I win 1,000 rupees in a lottery, the income tax ordinance requires, let's say, 100 rupees to be deducted from that total amount, and that would make complete sense. But as far as the goods given to distributors are concerned, I'm not sure if they fall under the meaning of price, or can be construed as falling within the meaning of a price within the context of Section 156, as there really is no context, there is no contest at all in this scenario. There is goods given to distributors on meeting certain requirements, and this is just an interesting way of creative interpretation of perhaps the Sindh High Court. So we have then the same principle also being used in a different case, which is, again, it's not been reported yet, and but the issue was in terms of entry 32 of the Federal List, which provides international treaties, conventions, and agreements, and international arbitration. And again, reading it, the word international is before treaties, but is not before conventions and agreements. And the question was, what types of agreements are again covered under entry 32? So applying this principle of a word is known by the company it keeps, there were three possible interpretations. Two possible interpretations. The first interpretation is that this covers all types of agreements. So you would have even a private person entering into a contract with any foreign investor or any foreign party as being falling within the interpretation of entry 32. But a more perhaps suitable interpretation of this would be that you would look at the phrase international treaties and understand its connotation. And that would be a government-to-government treaty. And similarly, it's either a bilateral or a multilateral convention. And therefore, the term agreements should be understood in that context, where you have international treaties and conventions being multilateral and bilateral. So an agreement can also only be where it is a bilateral or a multilateral agreement between two governments. It should not be any agreement signed between two persons, as a provincial government should also be allowed to enter into any foreign contracts if necessary. It may not enter into a foreign contract with a foreign government, as that would not be permissible. That becomes a subject of the federation. But if you have a government contract, if you have any other agreement, a government with an investor, that should not be covered by entry 32. And that's, of course, the understanding which becomes consistent across the entire phrase. So those are two examples of the same principle being used in two different scenarios, one being the income tax ordinance, the other the Constitution. And then we move on to another principle, which is the series qualifier canon. This does not find a direct mention within Durrani ceramics, but I think it can be applied to understand the decision better. So we have the entry which was in dispute in Durrani ceramics, which is taxes on mineral oil, natural gas, and minerals for use in generation of nuclear energy. So this is again another one of those very wordy phrases in the Constitution, which we're not sure of what it means. And there could be two possible interpretations, at least, of this entry. The first interpretation was given by some of the councils there in Durrani ceramics, was that the word taxes is to be seen as the operative word. So a tax on mineral oil is imposed by entry 51, also a tax on natural gas, a tax on minerals for use in generation of nuclear energy being the third type. So you divide the three nouns within entry 51 and then state that the word taxes will apply individually to each one of them. And you would have three taxes then being levied. But there was an alternative explanation, and that was that the phrase tax on mineral oil, natural gas, and minerals for use in generation of nuclear energy should be understood with the operative words being, or the phrase being, for use in generation of nuclear energy. And that was again the submission, which then meant that a tax on mineral oil could only be imposed where such mineral oil was used in generation of nuclear energy, and so on. So there are again two ways of seeing this. The Supreme Court preferred the latter interpretation, surprisingly, and did so because of the word and being used in entry 51. So they stated, by the use of and in between natural gas and minerals in entry 51, all the three items are to be read conjunctively with the words following them. In the said entry, and could have been substituted by or only if without the change absurd consequences would have followed. So the word and does a lot of heavy lifting for the Supreme Court in entry 51 and becomes the operative word to read the entire phrase. And they state that it should be read in a conjunctive manner, which is why the second interpretation should be preferred, which is that a tax can be imposed by the Federation where mineral oil is used in generation of nuclear energy, where natural gas is used in generation of nuclear energy, and where minerals are used for generation of nuclear energy. Of course, the problem becomes that mineral oil and natural gas aren't used for in generation of nuclear energy. There is just no way of using them. But the Supreme Court did not pay attention to that, or well, did pay attention, but decided to again state that the clear intention of the legislature was that the word and was being used. Now, despite my reservations with the judgment of the Supreme Court, I still think that they reached the right conclusion, but for a different reason. And that is that the series qualifier canon may explain the same issue with a bit more clarity. So as per the series qualifier canon, you can have a pre-positive modifier or a post-positive modifier to a phrase. So, for example, in the phrase institution or societies that are charitable in nature, you have charitable being the post-positive modifier, which controls the entire phrase. You have institutions which are charitable and societies which are charitable. Both of them will be, again, seen from the lens of being charitable. In entry 51, we can use the same analogy and state that use in generation of nuclear energy becomes the post-positive modifier. It applies across the board to all of the nouns, which again is the decision that was reached by the Supreme Court, that generation of nuclear energy should be read as applying to mineral oil, also as applying to natural gas, and applying to minerals. So these are the two possible ways of interpreting the same legislation, with the understanding being that you would reach the same conclusion, but just for different reasons. Now, there's another entry which I would like to share with you guys, and I would seek your, again, interpretation of it. So this is entry 49. It says taxes on the sales and purchases of goods imported, exported, produced, manufactured, or consumed. So we have two interpretations of this possible. The first is that you could have a tax on the sale and purchase of goods, with the goods then being imported, exported, produced, manufactured, or consumed. Or you could have the interpretation that a tax on the sales and purchases of goods is just one of the events. Then you would have a tax on imports, a tax on exports, a tax on manufactured goods, and so on. So these are the two possible ways of interpreting the same legislation, with the understanding being that you would reach the same conclusion, but just for different reasons. Now, despite my reservations with the judgment of the Supreme Court, I still think that they reached the right conclusion, but for a different reason. a tax on production, a tax on manufacturing, and a tax on consumption. I see someone has raised their hand.
Ji Azaz, so some participants have requested if you can also make it a bit bilingual in Urdu and English.
जी जी बिल्कुल
Explanation.
जी, ऑफ कोर्स, बिल्कुल 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 बिल्कुल।
Okay.
जी, तो इसके अंदर जी दो आपके तरीके हैं इसको पढ़ने के लिए। तो यू हैव पहला जो तरीका है कि आप इसको टैक्सेस ऑन द सेल्स एंड परचेजेस ऑफ गुड्स को आप पढ़ें कि जैसे वो ऑपरेटिव पार्ट है, कि वो ही कंट्रोल करेगा सारी की सारी फेस को। आपका दूसरा तरीका ये है कि आप इसको पढ़ें कि टैक्सेस ऑन द सेल्स एंड परचेजेस ऑफ गुड्स सिर्फ एक आइटम है और इम्पोर्ट्स एक्सपोर्ट्स प्रोड्यूस्ड मैन्युफैक्चर्ड और कंज्यूम दूसरी आइटम है। क्या इन दोनों में से अगर आप लोगों के कोई ख्यालात हैं कि कौन सी इंटरप्रिटेशन बेहतर है तो आप बताएं, वरना मैं फिर इसको हाई ले जाता हूँ सुप्रीम कोर्ट की जजमेंट्स के ऊपर जैसे उन्होंने उसको इंटरप्रेट किया हुआ है। सो आई जस्ट वेट फॉर आई थिंक अ फ्यू सेकंड्स देखने के लिए कि इफ समबडी हैज एन इंटरप्रिटेशन।
If you have any interpretations, please raise your hand and we can give you the mic, or you can leave your response in the chat box as well.
जी, तो post positive
Hafsa
modifier for the word जी
So Hafsa has written
जी
first, someone else is, Bushra has written post positive modifiers for the word goods.
जी, तो now there are two interpretations like I said, दोनों interpretations जो हैं वो सुप्रीम कोर्ट ने इंडोर्स की हुई हैं डिफरेंट डिसीजंस। जो फर्स्ट इंटरप्रिटेशन थी वो ये है, सॉरी जो सेकंड इंटरप्रिटेशन थी वो ये है कि आप इसको पढ़ें इन मास्टर फॉर्म जजमेंट कि नाउ एज अ रिजल्ट import, export, production, manufacture, and consumption are distinct taxable events, independent and irrespective of sales of goods. तो इसकी वजह से वो ये कहते हैं कि अगर आप दोबारा पढ़ें एंट्री 49 को, तो taxes on the sales and purchases of goods becomes just the first part, और वो एक टैक्स लगाता है, जबकि टैक्स को आप ऑपरेटिवली पढ़ेंगे और इंपोर्ट्स, एक्सपोर्ट्स, प्रोड्यूस्ड, मैन्युफैक्चर्ड और कंज्यूम्ड को आप सेपरेटली पढ़ेंगे, तो ये सब पे टैक्सेस लगाते हैं। ये भी एक जजमेंट है सुप्रीम कोर्ट की। And then you have the second judgment of the Supreme Court then stating the complete opposite. It says the first part is the opening phrase, taxes on the sales and purchases of goods. This phrase controls the ensuing second part. तो वो यही कह रहे हैं कि आपने taxes on the sales and purchases of goods को पढ़ना है as the pre-positive modifier, और वो कंट्रोल करेगा सारी की सारी फ्रेज को, कि आपने इंपोर्ट्स को भी उसके साथ देखना है, एक्सपोर्ट्स को भी उसके साथ देखना है, प्रोड्यूस्ड को उसके साथ भी देखना है, मैन्युफैक्चर्ड को भी और कंज्यूम्ड को भी। तो यहाँ पे दोनों इंटरप्रिटेशन हैं, और इवन दो हजरत हुसैन के अंदर उन्होंने क्लियरली कहा नहीं है कि मास्टर फॉर्म हैज बिन ओवररूल्ड, लेकिन उसकी बनती यही अंडरस्टैंडिंग कि शायद वो ओवररूल हो चुकी है। So you have these two interpretations of the same entry being promulgated or being passed by the Supreme Court. और हमें exactly sure it अभी भी sure नहीं है कि exactly कौन सी interpretation होगी जो होनी चाहिए, which shows कि आप जिस टाइम पे जो interpretive principle लगाना चाहें वो आप शायद लगा सकते हैं to reach your own conclusion. And इसके अलावा जी the last thing that I would like to share is how to read provisos. Provisos आपके होते हैं कि आपकी एक main provision होती है और उसमें से एक्सक्लूड कर देती है एक सर्टन आइटम, कि आप लिख देते हैं कि जी प्रोवाइडेड सर्टन समथिंग एल्स नहीं अप्लाई करेगा मेन पार्ट को। तो यू हैव द डिसीजन ऑफ पाकिस्तान मैच इंडस्ट्रीज 2019 SCMR 906, उसमें इशू ये था कि एक SRO इशू हुआ था बाय विच वाज इशूड बाय द फेडरल गवर्नमेंट, जो कि एक एग्जेम्पशन ग्रांट करता था इन टर्म्स ऑफ सेल्स टैक्स। तो वो ये कहता है कि द फेडरल गवर्नमेंट is pleased to direct that supplies of end products made by the manufacturers or producers of all such industrial units which are not already in existence and have been set up in these special industrial zones shall be exempt from the sales tax payable under the said act. अब हमें emphasize करना चाहिए यहाँ पे कि उन्होंने all such industrial units लिखा हुआ है। तो you have manufacturers or producers of all such industrial units, not simply a certain type of unit. जो प्रोवाइजो है वो कुछ और कहते हैं। प्रोवाइजो ये कहता है कि प्रोवाइडेड दैट द एग्जेम्पशन जो ऊपर उन्होंने दी हुई है 8 साल के लिए कि आपको सेल्स टैक्स नहीं देना पड़ेगा, will only be available to only such units which have opened letters of credit for the import of plant and machinery up to the 31st of January. अब इसकी वजह से यहाँ पे उन्होंने क्लियरली प्रोवाइजो में लिख दिया है कि आपके इंडस्ट्रियल यूनिट्स जिन्होंने इंपोर्ट किए प्लांट एंड मशीनरी, उनको ये एग्जाम्पशन मिलेगी। अब सवाल ये पैदा होता है कि क्या जो इंपोर्ट ऑफ प्लांट एंड मशीनरी है, क्या वो एक कंडीशन थी इवन फॉर द मेन एग्जाम्पशन या नहीं थी? तो अगेन जस्ट टू रीड SRO 77, वो ये कह रही है कि मैन्युफैक्चरर्स और प्रोड्यूसर्स ऑफ ऑल सच इंडस्ट्रियल यूनिट्स, वो ये स्पेसिफाई नहीं कर रही कि क्या आपने इंपोर्ट करनी है या आपने लोकली प्लांट एंड मशीनरी लगाई थी, वो किसको खुला छोड़ देती है, उसके ऊपर कोई एग्जैक्ट डिटेल नहीं आपको देती। प्रोवाइजो लेकिन आपको ये डिटेल जरूर देती है कि अगर आपके पास एक इंडस्ट्रियल यूनिट है जहां पे आपने LC खोली है और इंपोर्ट ऑफ प्लांट एंड मशीनरी, तो उसको आपने 31 जनवरी से पहले पहले आपने वो LC खोलनी आपको जरूरी है। अब दीज टू, ये जो दो आपके इश्यूज थे, ये दोनों इंटरप्रिटेशन सुप्रीम कोर्ट के सामने थी कि आपने कैसे पढ़ना है। क्या आपने इसको SRO को ऐसे पढ़ना है कि जो ऑल सच इंडस्ट्रियल यूनिट्स यहाँ पे लिखा हुआ है उसको आपने नैरो डाउन करके पढ़ना है कि यहाँ पे सिर्फ इंपोर्टेड यूनिट्स ही होंगे, या आपने प्रोवाइजो को पढ़ना है कि ये एक्सक्लूड कर रहा है, सिर्फ इंपोर्ट्स के लिए एक सर्टेन कंडीशन एक्स्ट्रा डाल रहा है, लेकिन जो बाकी आपकी यूनिट्स हैं उनके लिए ऐसी कोई कंडीशन नहीं है कि अगर आप प्लांट एंड मशीनरी लगा रहे हैं तो आपके लिए कोई कंडीशन नहीं है, लेकिन अगर आप इंपोर्ट करें तो सर्टेन कंडीशंस आपके ऊपर हैं। तो उसके ऊपर जो सुप्रीम कोर्ट है वो कहती है कि एज रिगार्ड्स प्रोवाइजोस, it is well settled that they are intended to qualify the main part of the provision and carve out an exception from the same, taking out as it was something that but for the proviso would be included therein. Such provisos are generally referred to as true provisos. तो इशू उन्होंने यही बनाया कि आप अगर SRO 77 को दोबारा पढ़ें, कि आपने देखना है कि ये जो प्रोवाइजो है अंडर दी SRO 77, वो एक्सक्लूड कर रहा है इंपोर्ट की प्लांट एंड मशीनरी को फ्रॉम द लार्जर जनरल एग्जाम्पशन ग्रांटेड, विच इज कि सारे इंडस्ट्रियल यूनिट्स को एग्जाम्पशन मिलेगी। तो उसकी वजह से आपको एक फायदा मिलता है कि ऑल इंडस्ट्रियल यूनिट्स विल बी ग्रांटेड द एग्जाम्पशन, लेकिन अगर आपने इंपोर्ट की हुई प्लांट एंड मशीनरी, वो प्रोवाइड कर रहा है, वो एक्सक्लूड कर रहा है और कह रहा है कि आपको LC खोलने की जरूरत थी कि आप 31 जनवरी से पहले पहले आप खोलें, वरना आपको इजाजत नहीं मिलेगी इस एग्जाम्पशन को इस्तेमाल करने के लिए। तो जी ये था जी, दीज आर जस्ट फ्यू ऑफ द इंटरप्रेटिव प्रिंसिपल्स जो पाकिस्तान में यूज होते हैं। अगेन गोइंग बैक, यू हैव द प्रिजम्पशन ऑफ वैलिडिटी, जहाँ से हमने शुरू किया था, जो कि एक जगह पे इस्तेमाल हुआ है बाय द सुप्रीम कोर्ट, जहाँ पे उन्होंने लेजिस्लेटिव एंट्रीज को बहुत ब्रॉडली कंस्ट्रू किया था ताकि आप उसको आप कॉन्स्टिट्यूशन के साथ रख सकें स्टैचूट को, और एक स्टैचूट को ज़्यादा रहने दें। उसके बाद यू हैव the same principle being used in a different manner, which is reading down. You have also the understanding of the Supreme Court कि आप अब चीज़ें पढ़ भी सकते हैं आइन के अंदर अगर आप पढ़ना चाहें, और वो शायद ज़्यादा मुश्किल है कि आप उसकी और एग्जांपल्स ढूंढ सकें पाकिस्तान में इन द फ्यूचर, लेकिन एटलीस्ट एक दफ़ा तो ये हो चुका है। उसके अलावा वी हैव सर्टन अदर प्रिंसिपल्स जो अप्लाई करते हैं, ये है वर्ड इज नोन बाय द कंपनी इट कीप्स, दिस अगेन अप्लाइज बोथ टू द कॉन्स्टिट्यूशन एंड टू स्टैट्यूट्स, अगेन डिपेंडिंग कि आपका कॉन्टेक्स्ट क्या है और कहाँ पे अप्लाई इसको करना है। एक एग्जांपल उसकी स्टैट्यूट में है, एक एग्जांपल उसकी कॉन्स्टिट्यूशन में है। यू हैव द सीरीज क्वालिफायर कैनन, जो कि आपके बहुत सारी एंट्रीज ऑफ द फेडरल लिस्ट के अंदर लगता है। एक एग्जांपल उसकी एंट्री 51 थी कि आपका जनरेशन ऑफ न्यूक्लियर एनर्जी कंट्रोल करेगा या टैक्सेस कंट्रोल करेगा, उसकी अंडरस्टैंडिंग को। और इसी तरह दूसरी एग्जांपल थी आपकी एंट्री 49 की, जहाँ पे शायद हमें लगता है कि दोनों तरीकों से आप उसको पढ़ सकते हैं और सुप्रीम कोर्ट भी ये मानता है, लेकिन शायद बेहतर तरीका यही है कि आप टैक्सेस ऑन द सेल्स एंड परचेजेस ऑफ गुड्स को एज द क्वालिफायर पढ़ेंगे, देन यू हैव प्रोवाइजोस। जी दैट्स ऑल फॉर टुडे जी, अगर कोई और किसी के कुछ सवाल है तो वी आर मोर देन हैप्पी टू टेक सम।
थैंक यू एजाज, वी स्टिल हैव 10 more minutes. अगर किसी के पास कोई सवाल है तो प्लीज रेज योर हैंड्स एंड यू कैन आस्क एजाज.
जी, if there's something that needs to be repeated, I can understand कि I think I was going pretty fast, मुझे कोई comments भी नजर आए तो रिपीट भी किया जा सकता है अगर कुछ जरूरी है। 49 जी, तो 49 के अंदर अगेन आपके दो पार्ट्स हैं। आपका एक पार्ट है जो देखता है टैक्सेस ऑन द सेल्स एंड परचेजेस ऑफ गुड्स को, और फिर आपके फ्रेजेस हैं, उसके वर्ड्स हैं, उसके बाद टर्म्स लिखी हुई हैं जो हैं इम्पोर्टेड, एक्सपोर्टेड, प्रोड्यूस्ड, मैन्युफैक्चर्ड और कंज्यूम्ड। सुप्रीम कोर्ट ने इसी एंट्री को दो डिफरेंट केसेस में देखा हुआ है और दो डिफरेंट केसेस के अंदर कोशिश की थी उसको इंटरप्रेट करने की, और दोनों में डिफरेंट उन्होंने कंक्लूजन्स ड्रॉ किए। एक में वो सुप्रीम कोर्ट कहता है कि टैक्सेस ऑन द सेल्स एंड परचेजेस ऑफ गुड्स है जिसको आपने देखना है कि वो कंट्रोल करे सारी फ्रेज को, और वो डिसीजन है आपका हजरत हुसैन का, तो जहाँ पे वो कहते हैं कि आपकी जब तक गुड्स सेल और परचेज नहीं होगी तब तक उसके ऊपर इंपोर्ट एक्सपोर्ट के ऊपर टैक्स नहीं लग सकता। तो आपने फर्स्ट पार्ट को देखना है कि वो कंट्रोल कर रहा है। आपकी दूसरी इंटरप्रिटेशन है जो कंप्लीटली इसके ऑपोजिट है, वो ये कहती है कि आपने टैक्सेस ऑन द सेल्स एंड परचेज ऑफ गुड्स को कंप्लीटली इंडिपेंडेंटली देखना है, वो बिल्कुल भी कंट्रोल नहीं करती पूरे फेस को, और एक टैक्स लग सकता है इंपोर्ट पे भी इसके थ्रू, एक्सपोर्ट पे भी इसके थ्रू, मैन्युफैक्चर पे भी, कंजम्पशन पे भी, और वो इसको इंडिविजुअली देख रहे होते हैं। तो दोनों आपकी जो पॉसिबिलिटीज हैं वो एग्जिस्ट करती हैं, एक ही इंटरप्रिटेशन चलेगी ऑब्वियसली, लेकिन दोनों अभी के लिए फील्ड में है। जी, जस्ट टू रैप अप, तो आपके डिफरेंट प्रिंसिपल्स अप्लाई करते हैं। किसी के पास यूजुअली सही जवाब होता नहीं है कि कौन सा प्रिंसिपल अप्लाई करना चाहिए कौन सा नहीं करना चाहिए। द एग्जांपल ऑफ दुरानी सिरामिक्स वाज देयर कि आपके इवन दो इंटरप्रेटिव प्रिंसिपल्स हैं जो इसको पढ़ने में हमें आसानी देते हैं, लेकिन द फैक्ट ये रहता है कि एक्चुअली आपके कोई भी ऐसे मिनरल ऑयल या नेचुरल गैस के कोई आइटम्स नहीं हैं जो कि जनरेट कर सकती न्यूक्लियर एनर्जी। वो यूरेनियम या प्लूटोनियम जनरेट करती हैं, मिनरल ऑयल नहीं करती। लेकिन इसके बावजूद कि यहाँ पे शायद एक कॉन्स्टिट्यूशनल प्रोविजन इनफेक्टिव बन रही थी, उसको सुप्रीम कोर्ट ने यही देखा कि हमें नेचुरल प्लेन मीनिंग ऑफ द वर्ड में ही चलना है, और उसके हिसाब से ही हमें आगे उसको इंटरप्रेट करना चाहिए। जी, मैं दो और सवाल है जी, पहले वो मैं उस पर जवाब दे दूं। पहला सवाल है कि जी कैन यू प्लीज एलैबोरेट ऑन प्री मॉडिफायर्स एंड पोस्ट मॉडिफायर्स। तो अगेन प्री मॉडिफायर यहाँ पे अगर होगा, सॉरी, हम इसको अगर देखें इंस्टीट्यूशन और सोसाइटीज के एग्जांपल ले लेते हैं, इंस्टीट्यूशंस और सोसाइटीज आर चैरिटेबल इंटर। यहाँ पे जो चैरिटेबल पार्ट है वो एक पोस्ट पॉजिटिव मॉडिफायर है, वो कंट्रोल कर रहा है कि आप इंस्टीट्यूशन और सोसाइटीज को कैसे समझना है। या अगर आपका चैरिटेबल वहां लिखा होगा विच इज ऑफ कोर्स द एडजेक्टिव विच इज बीइंग यूज्ड टू डिस्क्राइब कि नाउन्स क्या है, तो आपको समझ नहीं आएगी कि कौन सी सोसाइटीज है कौन सी इंस्टीट्यूशन इस फ्रेज के नीचे आती हैं। आपकी बहुत सारी इंस्टीट्यूशन हैं जो कि चैरिटेबल नहीं होती और सोसाइटीज हैं जो चैरिटेबल नहीं होती, तो यहाँ पे द मॉडिफायर इज चैरिटेबल, और उसके हिसाब से आपने दोनों इंस्टीट्यूशंस और सोसाइटीज को पढ़ना है। प्री पॉजिटिव मॉडिफायर इज, जैसे यहाँ पे हमने एंट्री 49 में देखा कि वो टैक्सेस ऑन द सेल्स एंड परचेजेस ऑफ, वो एक फ्रेज है, वो मॉडिफाई कर रहा है पूरे मीनिंग को ऑफ द एंटायर फ्रेज, कि इंपोर्ट्स को भी आपने सेल्स एंड परचेजेस ऑफ गुड्स के हिसाब से देखना है, एक्सपोर्ट्स को भी उसके हिसाब से देखना है। तो अगर आपने फॉर एग्जांपल सेल्स टैक्स लगाया है ऑन द सेल्स एंड परचेजेस ऑफ गुड्स पे एक टैक्स है, तो वो इंपोर्ट्स पे भी तभी लगेगा अगर उसमें सेल और परचेज ऑफ गुड्स इन्वॉल्व होगा, एक्सपोर्ट भी तभी लगेगा जब सेल एंड परचेज होगा, प्रोडक्शन पे भी तभी लगेगा, मैन्युफैक्चर पे भी तभी लगेगा, कंजप्शन भी तभी लगेगा। आप सिर्फ ऐसे ही टैक्स ऑन इंपोर्ट्स ही लगा सकते हैं 1949, उसके लिए शायद एक सेपरेट एंट्री है, लेकिन आप यहाँ इसके नीचे नहीं लगा सकते। तो प्री पॉजिटिव मॉडिफायर यहाँ पे ये है कि आपका एक बड़ा क्लियर एक फ्रेज है जो कि पूरी की पूरी बाकी एंट्री को कंट्रोल करता है, जैसे हजरत हुसैन में जस्टिस साकिब निसार साहब ने बताया था कि ये कंट्रोल करेगा बाकी फ्रेज को, कि द फर्स्ट पार्ट बिकम्स एज कंट्रोलिंग द एंटायर सेकंड पार्ट, और आपने उसको इंडिविजुअली नहीं देखना, इंडिपेंडेंटली नहीं देखना, इसको देखना है कि वो कंट्रोल कर रहा हो। इसके अलावा आई थिंक एक और सवाल था। My question is, what about situations where law is silent on an issue? Is it the presumption of legality that will be considered? For example, if Companies Act is silent on conversion of debt into equity, can we assume we can go ahead with the same? जी, यूजुअली आपकी जो कॉमन प्रिंसिपल है, जनरल प्रिंसिपल अप्लाई करता है, वो यही है कि एवरीथिंग इज विच इज नॉट डिसअलाउड इज अलाउड। आपकी सेक्शन 151 ऑफ द सीपीसी का भी यही अंडरस्टैंडिंग है कि अनलेस आपकी एक स्पेसिफिक आइटम है जो कि डिसअलाउ की हुई है, उसके अलावा उसकी अलाउंस होती है। लेकिन अब विद द कंपनीज एक्ट यहाँ पे शायद वो स्लाइटली डिफरेंट होगा, कि उसकी स्पेसिफिक आपको जो प्रोविजंस है अंडर द कंपनीज एक्ट व्हिच इज अ हेवीली रेगुलेटेड स्पीशीज ऑफ लॉ, उसके अंदर देखना होगा कि क्या कन्वर्जन ऑफ डेट इनटू इक्विटी की इजाजत है या नहीं है, और उसके अगर कोई प्रेनम्बरल भी इसकी प्रोविजंस हैं तो उनको भी देखना होगा। यहाँ पे शायद ऐसी एजम्पशन एग्जिस्ट नहीं करती ऑटोमेटिकली, क्योंकि आपके आर्टिकल्स ऑफ एसोसिएशन भी होते हैं, आपके मेमोरेंडम ऑफ एसोसिएशन भी होता है। उसको भी साथ देखना होगा कि क्या एक कंपनी को खुद इजाजत है ये करने की या नहीं करने की, और उसके बाद फिर आप लार्जर रेगुलेटरी फ्रेमवर्क भी देखते हैं कि क्या उसके अंदर इजाजत है या नहीं है। सो वहाँ पे इतना क्लियर, शायद क्लियर एग्जाम्पल नहीं होता, लेकिन प्रिजम्पशन वही रहती है कि आपको यहाँ पे वो प्रिजम्पशन ऑफ कॉन्स्टिट्यूशनलिटी नहीं आती, यहाँ पे प्रिजम्पशन ऑफ लीगैलिटी आती है। जी, लीगल फिक्शन इज अ पार्ट ऑफ इंटरप्रिटेशन। जी बिल्कुल, ये दिस कुड हैव बीन वन ऑफ द आइटम्स दैट वी कुड हैव डिस्कस्ड टुडे। लीगल फिक्शंस आपके डीमिंग क्लॉजेस होते हैं, आपका जहां पे भी लिखा होगा कि समथिंग समथिंग इज डीम्ड टू बी रेड एज समथिंग एल्स, तो वो एक उसको लीगल फिक्शन उसको अंडरस्टैंड करते हैं। उनकी इंटरप्रिटेशन के भी सर्टेन प्रिंसिपल्स हैं कि आपने एक डीमिंग क्लॉज को भी, इवन दो वो एक चीज को क्रिएट कर रहा होता है कि जो कि नहीं होती, आपने उसको कैसे इंटरप्रेट करना है। एज फार एज आई रिमेंबर, आई थिंक आपने उनको भी थोड़ा सा स्ट्रिक्टली कंस्ट्रू करना होता है। यू कांट सिंपली स्टेट के बस आपने अगर कह दिया कि अगर ए इज डीम टू बी बी, तो उसके अंदर सी और डी भी शामिल हो जाएंगे, उसको आपने बी की हद तक ही रखना होगा, उसके अलावा नहीं आप उसको देख सकेंगे। जी, एनी अदर क्वेश्चन जी?
I think that's all. Uh, yep. Thank you so much, Azaz. Thank you to everyone who joined, and we'll wrap it up.
My pleasure जी, thank you for everyone, thank you to everyone for joining, and hope to see you guys soon.